and bring in national trial attorney Michael Jaafar. Michael, good to see you. Also want to let our viewers know the witness who was immediately before this one, a digital forensic analyst, Karen Patterson. We were listening to see if she was going to be able to reveal something about the text messages between these two. She did download everything from the phones, but someone else is going to testify about the report. So we haven't heard that yet. But Michael, I want to know from you, what questions are unanswered for you in this trial so far? What do you want to hear going forward?
Really, I want to see, was there a history between these two people? Were they fighting? Were they arguing? Have there been any reports of any type of abuse or any type of domestic violence? It matters because the events are kind of outlandish. They're kind of unbelievable that a deputy who's trained on what's called muzzle discipline, which you never dry fire into a person, dry fired into a person, into a human being, right? Forgot that it was loaded or not. It's not relevant to me. Why did he dry fire into her? So I want to see whether or not there's type of history between these two. And if there isn't any history between them, the same questions remain for me.
Michael, what's interesting to me is here you have the police interviewing a sheriff's deputy. He's a sheriff's deputy. He knows what laws say. And what he says was, it was an accident. We were training. He says that during this interrogation. My question for you is, but that's not a defense under the law. So what if it was an accident? He could still be found criminally responsible.
Maybe I was thinking the same thing. Maybe he was drunk. Maybe he was candid. Maybe he thought himself that really, he's lucky that he wasn't charged with first-degree murder, right? And so maybe that was a play for him to say, look, I got to fess up and tell them that something happened because they're not going to just let me off the hook for no reason. So maybe that was in his mind, or maybe he just wasn't thinking at all. Maybe he just was going through the shock and had the adrenaline of the fact that he just murdered a human being in his home under his care and under his duty, and he should have known better. But you are correct. It is mysterious as to why he was admitting to that.
Yeah, and we are going to get in our break because when we come back, we're going to be able to hear that police interrogation video.
With us, national trial attorney Michael Jaafar. Michael, as we're listening to this testimony unfold, I think that the story that the defendant gave is starting to fall apart.
It really is. I've been vacillating on whether or not he helped himself with that police interview. Most of the time, you always hurt yourself by speaking to police after you're accused of a crime. Once in a while, you help yourself. Yes, the story is falling apart, but I think, Judge Ashley, as I see this through, I think this man knew he was cooked, and the prosecution did him a favor by charging him with manslaughter or murder, not felony murder, or first-degree murder or second-degree murder, because I think he knew that there was no way out of this, so he had to speak to police. Can you imagine if he didn't speak to police? What would have had? They would have charged him with first-degree murder or second-degree murder and forced him to defend himself and come up with a story, right? I think he got ahead of the ball. I think he was sobering up and then started realizing, look, I'm going to go to jail either for the rest of my life or for 20 years. And I think he elected for the 20 years.
Well, why did he not take a plea? Or he was charged with manslaughter. Mm-hmm. He doesn't quite, it seems, have an argument against this recklessness. He could have, and tell me if I'm right, gone in front of a judge to argue just the sentence rather than the issue of whether or not this was manslaughter.
That's an excellent question. I was thinking about it on the break. I don't think a plea was offered in here because here's why. We all know the prosecution's overcharge, right? You overcharge because 99.5% of cases end in a plea. And how do they end in a plea? You overcharge, you reduce it, and then you enter into a plea. I don't think they offered. I think they charged him the right charge. I think they intentionally did not overcharge him. I think he had no choice but to plead right on the nose. And then, like you said, go in there and argue the sentence. Maybe he just thought he would just try his luck, but I don't know why he didn't take a plea. He should have.
All right, Michael Jaafar, thank you so much for your analysis.